Good afternoon, everybody. This is John Marcano with Probate Matters, and today we're here to talk to you about why does it take so long to get through the probate process in the state of California. But before we do, I just wanted to let you know that this video is being sponsored by Advanced My Inheritance. So at Advanced My Inheritance, we deal with this subject every single day as we work with heirs and getting them advances because they are stuck in this elongated process and can't wait to get their funds. So let's talk about why it takes so long. Well, there's a lot of steps that have to happen in order to get to final distribution. And I thought it would be good just to talk about the many steps involved from the beginning of the process to the end of the process and give you a little bit more insight so that maybe you can understand of why things take as long as they do. I just want to pause right here and put on screen what it looks like from a timeline perspective of getting a case to go through probate court in California. Check this out. The average of what I'm seeing over the last 6-7 years in the industry, I'm seeing that typically, outside of COVID was a lot longer. But what I'm typically seeing is the fact that on average, it takes 12 to 18 months to get through the probate process in the state of California. That's a long time. And that's if everything is relatively smooth and, there's no objections and there's no infighting and the property sells, very quickly and, everything goes as planned. And so we know that just doesn't always happen. But let's start off and talk about what the process looks like. So the first step in the process is for an executor to be named. So in order for an executor to be named, they need to actually file a petition with the court in order to go in front of the court, this person, in order to be named the executor. So the first step is a petition is filed. The court then sets a date. Typically that date is roughly 60 days out. Sometimes longer, sometimes shorter, but about 60 days out. And then the person and their attorney typically go in front of the court. The court reviews the, sort of initial estate information, understands the background of the person applying to become the executor. And as long as there's, nothing in their background and nothing, no objections by the family, it should go smooth and ultimately the executor will be named. So that's great because that's the very first step. But, right off the bat, you're already at 60, 70 days, right? Now, the next step that the executor can now finally take is they can go ahead and they can file what's known as notification for the claims period. So what they do is they file a notification inside a local paper, that's the law, to let people know, let the world know, that unfortunately the decedent has passed and that if there's any claims to be had against the estate, that now is the time to file them. So they typically have 60 days in order to file that notice from the time that they receive the letters of administration or become the executor. And then the creditors typically, they have roughly 60 days in order to file the claim. Now, in California, they're a little bit more understanding. And so, in general, what they look at is accepting claims from creditors, the bills that were owed from the person, before they passed. Those claims can be paid from a year from the person's death. So, as long as they make the claim from a year from the person's death, those claims typically are honored. Now, I'm going to do a little sideline commercial for an attorney. Now, I'm not an attorney, but I'll just give you my gee-whiz advice. I know sometimes people like to go without an attorney because they think they're saving money, but I will tell you that in almost every case, the attorney is absolutely saving you money. They're saving you time. They can help you navigate the process. They can keep you out of harm's way legally. And I highly recommend that, yes, you can do probate you can become an executor in probate without an attorney, but I highly recommend that you do use an attorney. So anyway, I'll move off that soapbox and continue with, what's continue with ultimately what's the next step. So the next step is where the claims have been filed, petition's gotten, the claims have been filed. The next step is for the inventory to be rounded up. So the executor has to go ahead and have the inventory put together. Inventory simply just means all the assets that the decedent owned, cars, boats, planes, whatever it might be, right? Houses, bank accounts, stocks, bonds, businesses. And so it's up to the executor to go ahead and put together a list of all of the assets, and then also a list of all of the claims, all of the bills that have been left behind. They then take that and they file with the court to let them know these are all the assets and these are all the liabilities. In that process of putting together the inventory on the assets, they also have to have things appraised. So they may use in California the referee to get an appraiser to go out and look at any and all property, or businesses if there's a family business or anything like that. They may have somebody come and appraise the jewelry. They may have some auctioneers come and appraise the contents of the house. So that's their job, is to make an inventory list of every single thing the decedent owned and put a price on it, so that ultimately when it gets liquidated, that can go toward, one, paying off the liabilities, and then ultimately after the liabilities are paid off, it go to all of the heirs, right, as a final distribution. So now we've got the petition was filed and granted. We know the inventory now has been filed. We know that the claims notice has been filed. Now you're deep into it. You're probably 6 to 9 months inside this estate process. Hopefully the house is on the market and will be sold. Sometimes, that can be a delay. If it takes a long time to sell the house, that can delay everything. Or if there's somebody living in the house and, maybe sometimes I've seen heirs where they don't want to get out right away. These are all things that can start pushing, past that 18 months, past that, 12 to 18 month mark, and start to see, upward of 2 years or more. So, hopefully the house sells and, all the assets get liquidated. And then once those things happen, the executor's job is to continue the process. And part of the process is to make sure that they file that last tax return. So they have to file with the tax board and make sure that there's no outstanding state or federal taxes or tax liens. They also have to check with the health and safety department, health and human safety department, to make sure that in fact, if the person had any bills left over from Medicaid, hospital bills, any assisted living bills, or assisted living, anything like that, that can be cleared as well. Those bills will come up or not if they didn't have them. So they have to file with the tax board. They have to file with the health and health department, and they have to make sure that all claims have been received. Once they do that, and they have all of the bills received, and they have all of the assets, liquidated, then they can go ahead and file for what's known as, final accounting. And the final accounting essentially goes in front of the judge, and they essentially say, okay, Your Honor, this is what we have. We have all of these assets that have been liquidated. The money's in an estate blocked account. Here are all the creditors' claims that need to be paid. And, this is where your lawyer really comes, to the rescue on a lot of things. The lawyer a lot of times can, fight claims that may not be legitimate or may be past their time of, like I said, there's timeframes that claims have to be filed by. Well, if they fall outside those timeframes, then it's up to your lawyer for them to help you. So they can save you lots of time, lots of money, and get you through right now, which is, final accounting. Once final accounting is approved, the judge will go ahead and say, go ahead, it's approved. You can now pay off the bills. And once all those bills are paid off, you can go ahead and fund all of the heirs their distribution or their inheritance. Once that's done, then everybody signs off where they get proof that the claims have been paid off. They get proof that the heirs have received their money. And the probate case can get wrapped up and, pull the journey to a close. So if you have any questions whatsoever, please leave comments on the bottom of the video. Feel free to get in touch with us. Again, this is Advanced My Inheritance, and I'm John Marceno, and this has been Probate Matters. Thank you and have a great day.